With paid sick leave, California's Healthy Workplaces, Healthy Family Act went into effect in 2014, and it requires employers to provide a set amount of paid sick leave to employees working in California. And although the act establishes minimum requirements, employers have the option to provide more time off than the minimum required under the act. So you can always be more generous to your employees. You just can't be less generous than what the law provides. In addition to California's mandatory paid sick leave law, multiple jurisdictions also provide mandatory paid sick leave benefits on both the local and the national level. There can be significant differences between the state law and the local laws. All employees who on or after July 1st, 2015 have worked in California for the same employer for 30 or more days within a year from the beginning of employment are entitled to this paid sick leave. There are only limited exceptions, but part-time and full-time employees are covered. Exempt and non-exempt employees are also covered. Temporary, seasonal, and even out-of-state employees can be covered too. Out-of-state, it's if they spend enough time working for your business here in California. So it gets a little complicated if you have employees moving in and out of California or coming to California occasionally to work. The following groups of employees are not covered by the act and therefore are not entitled to paid sick leave. And that includes employees covered by a collective bargaining agreement that provides for sick leave, has binding arbitration, and meets other requirements, including a regular hourly rate of pay of not less than 30% more than the state minimum wage. Construction employees, so if you're one of our clients that is in the construction industry, it doesn't apply to them under certain types of collective bargaining agreements. Providers of publicly funded in-home supportive services under certain sections of the welfare and code, and then certain air carrier employees who are provided time off that is equal to what is provided under the act, and then certain public retired annuitants. An employee can use paid sick leave for the diagnosis, the care, the treatment of an existing health condition or preventative care for themselves or for a family member. So for example, here an employee can take this paid sick leave for a cold or other sickness, for a sick child, or for an annual physical, or another preventative care like the flu shot. And a family member under California's sick leave law is either a child, and a child is somebody, it actually as a definition of what that means, it's a biological, adopted, foster child, stepchild, and it now has been expanded regardless of the child's age or dependency. So if you're 60 years old working, if you have an employee who's 60 years old and working and they have a 30-year-old child, they can still take sick leave to care for that child. Another type of family member is parents, or even now parent-in-law. Parent is actually defined again as biological, adoptive, or foster parent, step-parent, legal guardian, and other family members also include spouses or registered domestic partners, grandparent, grandchild, and sibling. And for those last three, grandparent, grandchild, and sibling, that is only related to California law under CFRA. And that is in place if your business is over 5 or more employees. Or if you're out of state and you have one person in California and you have 4 somewhere else, that still applies to that California employee because your whole business is over 5 employees. So we get a lot of questions on that.